The conferment of the title of Leader of the Opposition, or LO, on Pritam Singh in August of 2020 was, in my view, a false start. It was destined to run into problems because the legal basis of the title is unclear. It's not enshrined in any official document of Parliament, at least not that I'm aware of, and it's certainly not in the Constitution of the state. The question is whether the leader of the executive branch is the right person with the authority to confer or remove the title of LO from an elected member of the legislative branch. This, in turn, begs the question, if not the PM, then who or how? In this commentary, I do not wish to examine whether it was right or wrong to withdraw the title of LO from Pritam Singh. There's already been much worthy debate and discussion on this. My question is this: why didn't Parliament give legal standing to the title of Leader of the Opposition before conferring it on Pritam Singh in August of 2020? To date, there is no statutory procedure in Singapore law governing how to appoint or revoke the LO designation. This should have been in the standing orders of Parliament before Pritam Singh was appointed Leader of the Opposition. Now, to better understand this whole matter, let's take a quick look at the practice in the UK and other jurisdictions that have adopted the Westminster-style of Parliament. The Singapore arrangement, in which the Prime Minister has the political discretion to appoint and remove the LO, is unusual for a Westminster democracy. In the UK, Australia, Canada, and India, the position of LO is legalised through appropriate acts of Parliament, such as the Ministerial and Other Salaries Act 1975 in the UK, as well as through parliamentary conventions. In all four jurisdictions, the appointment of the LO is automatic, meaning that the leader of the opposition party with the largest number of seats will automatically assume the position of LO. In India, the largest opposition party needs to get at least 10% of the seats in the lower house of Parliament for its leader to assume the post of LO. In all four jurisdictions, the Prime Minister or the ruling party has no role in appointing or removing the leader of the opposition. Now, whichever model Singapore wishes to adopt or adapt to, it is important that the position of leader of the opposition gains legal status, and this is entered into the standing orders of Parliament. It should be codified. There should be no ambivalence about who is entitled to assume the position of LO, the procedure and protocols governing this, and under what circumstances a sitting LO can be removed and how this is to be done. People are more educated and engaged today. There is a desire for clear, unequivocal explanation, failing which cynicism kicks in. There's a risk of people losing faith in public institutions such as Parliament. Promptness, consistency, and transparency, especially in communications, are key to ensuring public trust is not compromised.